Hi, everyone. Good afternoon. I'm David Brody. I'm with the Lawyers Committee for Civil Rights Under Law. I'm counsel and senior fellow for privacy and technology.
And I'm Gaurav, Laroia, policy counsel at Free Press. And just once again, would like to thank Access Now for having us here to talk briefly about a project our organizations are engaging in on protecting both civil rights and privacy. And so, as I said, our organizations and others in the room I know believe that civil rights are privacy rights, and that that data use restrictions must be part of that conversation in any comprehensive privacy regime. And I think, from our perspective, we think the notice and choice framework has failed, and it especially fails marginalized communities and people that don't have the kind of tech literacy to make informed choices in this environment. And I think we'd like to leave you with 3 takeaways. First, there's a real problem here. Secondly, fortunately, in the context of that problem, we don't need to reinvent the wheel. Civil rights laws that are protected against discrimination in the brick and mortar context for over 50 years are exactly the place we should be starting from and provide the framework for how we protect civil rights in the data economy and context. And then third, in that way, we must close any loopholes that prevent the application of civil rights laws to the online context. And as David will explain, our organizations have a proposal and draft legislation at freepress.net to see how that happens. And so I'm briefly going to do some table setting for the problem, and that it's, I think at this point, incontrovertible that algorithms and other data processing mechanisms can be both blatantly discriminatory and have disparate impacts. We believe that companies shouldn't be using our information about us and other characteristics to affect and adversely affect opportunities for protected classes such as people of color, women, LGBTQ individuals, religious minorities, immigrants, and other marginalized communities. And by way of examples, here's just a few. In employment, a ProPublica investigation found that employers like Uber were advertising jobs exclusively to men. A study by the nonprofit Upturn showed that predictive hiring algorithms, quote, reveal and reproduce patterns of inequity, end quote. And earlier this month, Facebook settled a case with the Communication Workers of America and the ACLU about ending discriminatory advertising for employment and housing on that platform. But of course, solving one problem at one company is not enough. When it comes to lending, a UC Berkeley study found that online mortgage lenders systematically charge Black and Latinx people more for loans. In the right to vote, of course, I think everyone's aware of the Russian interference in the 2016 election using commercially available tools. The Brennan Center recently had a report that malicious actors are continuing this behavior into 2018, and that, quote, voter suppression has gone digital. This also affects public accommodations, a concept David's going to explain. And a recent Amnesty report stated that platforms generally open to the public, like Twitter, are, quote, toxic places for women. And they've constantly failed in their duty to investigate abuse and violent threats in a transparent manner. And once again, the point I want to make is that we have the tools and the framework to address these inequities. And it needs to be made explicit that civil rights protections apply to online commerce just as they have in the brick and mortar context for 50 years.
All right. So our 2 organizations have come together to write an online Civil Rights and Privacy Act to discuss how to do comprehensive privacy reform with a prioritization and focus on civil rights. So, at a threshold level, it includes all of the sort of typical privacy protections that I won't go into a lot of detail about, but empowering the FTC, data security, use restrictions, individual rights for access and control. I think people in this room are generally familiar with the general structure of those sorts of things. But then we also have a lot of stuff that is particularly focused on protecting civil rights online. So we prohibit discrimination, prohibit the use of personal data to discriminate in employment, housing, credit, education, and insurance. And in so doing, we specifically call out both intentional discrimination, which most people are generally familiar with, but also discrimination by disparate impact. which is something that is well-founded in our civil rights laws going back 50 years to the Fair Housing Act and Title VII. And the concept here is that even someone acting unintentionally, the way that you process information could result in disproportionate harm to particular groups. And I think we are seeing a lot of that in the employment and housing context in particular. Our bill prohibits deceptive voter suppression, which surprisingly is completely legal today. So it might be a surprise to many people that the Voting Rights Act allows someone to say that, hey, you can text your vote. Send your vote here, text by vote. Or Democrats vote on Tuesday, Republicans vote on Wednesday. It is completely legal to disseminate that information. And the other big thing we would do is expand public accommodations laws to apply to businesses that provide goods and services online. And let me talk a little bit about what that means. Public accommodations laws, if anyone's not familiar, these are the laws that literally ended segregation. They say that if you are a business that is open to the general public, you have to serve all comers, and you cannot refuse or degrade service on the basis of race, sex, religion, etc. Because most of our civil rights laws were written long before anyone invented the internet, these laws don't apply to online businesses in many instances, especially public accommodations. There are some state public accommodations laws, notably California and New York, that actually do apply to online businesses, if anyone is, looking at novel things to look into. But most don't, and the federal public accommodations law doesn't, and this is just a historical oversight. If you are using the internet, using online businesses, services, whatever, you should not be refused service on the basis of your race or your gender or your sexual orientation or your religion or other sorts of protected characteristics. Our bill also includes transparency provisions similar to what a lot of other proposals are, but we come at it from a perspective of we really want to get under the hood to know how companies are using data to ensure that we can identify those disparate impacts. Right now, one of the big challenges in applying existing civil rights laws is that machine learning algorithms are a black box. Companies are not transparent about the data that they have, that they collect, that they sell, that they use. And so it's incredibly difficult to bring discrimination lawsuits. The big lawsuit that was settled with Facebook just a few days ago involving Communications Workers of America and the ACLU and a number of other great organizations, that is such a big deal because that sort of lawsuit is so rare. It's really difficult to do that sort of litigation, and it's difficult because we don't have enough information to get into court in the first place. The other part of transparency that's really important is bias and privacy risk assessments for data processing practices. As many people are probably aware, have heard about before, machine learning algorithms have a lot of inherent biases. And they have a lot of inherent biases because we as a society have a lot of inherent biases. And when you are feeding biased data into a system, it is going to export biased outcomes. And so when processes are being designed and implemented and reformed, there needs to be audits along the way to make sure that they're not discriminating. Two last things that we include. We do not preempt state laws that are not inconsistent. We believe that there should be a floor, not a ceiling, and the reason for that, and this was sort of touched on in the last panel, is that there are a lot of really good state civil rights laws that are inextricably intertwined with the use of personal information, whether you're talking about employment discrimination, housing discrimination, and there are many state civil rights laws that are better than federal laws, right? There are state laws that prohibit discrimination against LGBTQ individuals, and those laws are lacking at the federal level. And so if you go down the preemption road, are you going to inadvertently throw out a lot of really good state civil rights and consumer protection laws that protect marginalized communities? And finally, we do include a private right of action. And that's because historically, marginalized communities could not rely upon the government to vindicate their rights. It is essential for any civil rights law that there be the opportunity for the people themselves to have their day in court. And pretty much every civil rights law under the sun that has any teeth to it involves a private right of action. So that, in a nutshell, is our bill. And if we have any time for questions, we're open to questions.
Yeah, well, I'll also just say that I think it is important to bring up civil rights in the context of privacy and data processing. And I think there's an effort, fortunately we're seeing it here in DC, to bring these two technology and privacy and civil rights communities together to address this problem. It's fundamentally about what kind of civilization and community we're going to try to build in the 21st century. And if we want to have big data and technology recapitulate the kinds of discrimination we saw in the 20th century and entrench it further, or as we are creating a data privacy regime, try to work together to build a society that is more equitable, more just, and moves away from the kinds of practices that we could easily sleepwalk into.
Thank you very much.
We'll be around to talk about it later.
Yeah, if you have questions, come find us.